Tison v. Arizona, Court Case 481, U.S. 187, decided in 1987, by Spencer Cristoforo. A fascinating debate arises when looking at the Tison v. Arizona case. Questions of subjective evidence, as well as questioning whether it's ethical to sentence someone to death without committing any murders themselves, as well as sentencing someone to death without any evidence of an intent to kill. We can also look at the Eighth Amendment as possibly being broken for cruel and unusual punishment. The case began when Gary Tison was serving a life sentence for killing a prison guard in an Arizona state prison. Gary's 3 sons plotted to break him out, along with his cellmate Randy Greenawalt. On July 30th, 1978, the brothers put this plan into action. They took advantage of the prison's weekend family visiting policy. As if bringing drinks to a picnic, the brothers smuggled weapons including sawed-off shotguns in an ice chest. One brother aimed a shotgun at a lobby guard, and Greenawalt cut phone and alarm wires to make the escape go more smoothly. They continued the escape in the Tisons' Lincoln Continental, which was parked outside the prison waiting for them. As the Tisons were headed north to California, somewhere near the California border the tire blew out in the Continental. They flagged down an oncoming car, which happened to be the Linus's. John Lyons, a 24-year-old Marine sergeant, was distracted by John, who was showing him the tire. As he was showing him the tire, the other Tisons came out of the brush and forced the family into their car at gunpoint. They then drove into the desert. While in the desert, the gang held the family hostage and took many of their belongings. At some point, Gary Tison ordered his sons, Raymond and Ricky, to get the Linus's water. While the 2 brothers were off getting the water, Gary shot the Linus's in cold blood. According to Raymond and Ricky, they were both there and witnessed their father commit this crime to the Linus's. Gary Tison would eventually die in a shootout with police a few years later, but Ricky and Raymond were initially tried for the capital murder of the Linus's. They were predicated on the Arizona's felony murder state. This said that any murders carried out during a kidnapping or a robbery are eligible for the death penalty. After this first hearing that was very brief, the brothers were convicted. During a second hearing, 3 aggravating factors were proven. The first was that the Tisons had created a grave risk of death to others. Second, the murders were committed for pecuniary gain. This occurred when they took the belongings of the Linus's. Third, the murders were especially heinous and cruel. The court at this time still upheld the death penalty and convicted both brothers. The Tisons would eventually counter these claims by claiming Edmund. The Edmund clause originated in the Edmund v. Florida case. It stated that nobody is to be sentenced to death if they, the convicted, can prove no intent to kill. The Arizona Supreme Court, however, rejected this argument for 2 reasons. First, the brothers chose to be in a dangerous crime, and second, the death of the Linus's was a foreseeable outcome. The Supreme Court also found other differences between Edmund and the Tison case. First, Edmund did not actively participate in the murder and was not at the murder scene. The Tisons also admitted to contemplating as well as anticipating the use of lethal force. However, this still is not proven intent to kill, just that they were accepting of having to use lethal force. The court found other differences as well. First, the brothers saw that their father brutally killed the family, and while he was doing this, neither one attempted to prevent their father from doing so. The court also found that neither dissociated themselves from their father, the murderer, after the crimes were committed. They still continued in his aid to escape. A majority opinion was written by Justice O'Connor. She stated that the death penalties for the brothers were appropriate for 2 reasons. First, the brothers expressed great indifference to human life, and second, because both played a major underlying role in a dangerous crime. The majority won with a vote count of 5-4. However, this didn't matter because the brothers were under 21 at the time of the crime. This meant that they could not be executed. Dissenting was Justice Brennan. He first attacked the felony murder doctrine and called it a living fossil. He explained that the doctrine allowed for persons who neither committed murder nor intended to commit the murder be convicted. They found from the previous hearings that the trial judge's instructions were consistent with the prosecutor's argument. That is, there was no evidence of an intent or action. What this case also brings up is subjectivity and subjective evidence. That is, the indifference to human life and saying that they also had underlying major roles to one person could be considered not underlying major roles and not indifference to human life to another. The foreseeable standards the court used is also subjective evidence. How can you say that a foreseeable outcome of a prison break would result in an entire family being shot? Saying the Tison brothers played major roles is also subjective evidence. Remember, the Tisons did not commit any murders themselves, but were just there aiding their father in escape from the prison and happened to witness him kill a family. We can look at the Eighth Amendment, however, and see that it outlaws cruel and unusual punishment. That is, the punishment of a crime must be equal in degree to the crime itself. If we look into what the brothers actually did the brothers deserve to be executed even though they didn't kill anyone themselves? Three things that we can definitely take away from this case include, first, the courts have the ability to give death sentences to people who have not committed murders themselves. Secondly, subjective evidence can be used to convict someone of a crime and satisfy the death sentence. And thirdly, the Eighth Amendment we can look at as being highly subjective in itself. That is to say, what's cruel and unusual to one person may not be to another.